Now 3 p.m. So while we are waiting for everyone to filter in, I'm just going to make a few announcements. So the first announcement is that this session is being recorded. We will make it available to you via email in a few days' time. You also will have the opportunity to type questions into the Q&A, and at the end, we will try to get to as many as possible. With that, I'm going to pass it off to Noah for the introductions. So Noah, over to you.
Hello, everybody. Welcome. I'm Noah Mendelsohn-Aviv, Executive Director and General Counsel of the Canadian Civil Liberties Association. I want to thank you all for joining us today to hear about CCLA's work, and in particular from our main speaker, Harini Sivalingam, who I will introduce shortly, who's going to share with you some of the important work being done in CCLA's equality program. Before we begin our program, I would like to start with a land acknowledgement. We recognize that many people are joining us here today from different places in Canada, and you will be able to acknowledge the Indigenous lands that you are living on. We will not be able to acknowledge each of those, but CCLA's office and the speakers for this event are in Toronto, which is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabeg, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis peoples. In the spirit of reconciliation, we acknowledge the land that Indigenous peoples have lived on and taken care of since time immemorial. We are honored to be able to live and work on this land. And with that, I want to share with you an update on other activities that have been happening at CCLA the last little while before we move on to the in-depth description of the equality program. This has been an intensely busy and successful period for CCLA and CCLET, our education program, and our team has been a blur of activity. There's more than I could describe, even if I had the full hour, so here are just some of the key highlights. First thing I want to share is that this time last year, we were talking about the use of the notwithstanding clause in the Charter in Ontario to limit the freedom of association of workers' rights. We said then that the notwithstanding clause should never be used to violate basic human rights and civil liberties, and that every time the clause is used, it creates a dangerous precedent that it will be used again. This year, the notwithstanding clause is being invoked again in Saskatchewan to violate the rights of trans youth, and we went to Saskatchewan to raise public awareness, to do public engagement about the danger and the harms caused by using this clause to violate basic human rights and freedoms. In other areas as well, we continue to fight for freedom. We are fighting against proposed changes to bail in Bill C-48. The House of Commons passed the bill without the usual committee study and public engagement, so our team executed a rapid response media and advocacy strategy that garnered significant attention, and we are now seeking amendments at the Senate, where we have met with senators, submitted a comprehensive brief, and testified before a standing committee. We've also been to Parliament on two other issues in the last little while. One is Bill C-26, Canada's new cybersecurity legislation, where we focused on privacy concerns and on the broad ministerial powers provided by the bill for handling and disclosing people's personal information. The other is Bill C-27, concerning the inadequacies of Canada's proposed federal private sector privacy legislation. And that includes in particular, and we focused on inadequate attempts by government to govern the use of artificial intelligence. We've made our written submissions and we're waiting for the committees to set up their meetings so that we can be invited to testify. In addition, in 2023, and this is shocking, we have to continue to fight for open courts. There was a case of a Quebec trial that was held in secret without so much as a court record or file number, and we're fighting that. In Newfoundland, we received a decision on our challenge against the interprovincial travel restrictions during COVID. The restrictions, of course, are over, but CCLA and all of the parties wanted the court to go ahead and consider what the right to mobility means under Section 6 of the Charter. The Court of Appeal held that the issue was moot and did not want to proceed, and we are considering our next steps. In a case called the King and Kasai, the Supreme Court of Canada actually quoted from CCLA's factum, which is a very important form of recognition. This was a case about the role of amicus curiae in criminal proceedings. We had argued that amicus must be able to effectively assist people to ensure fair and equitable trials for marginalized, self-represented accused people, while also respecting their right to self-representation. We were also in court this month on the question of whistleblowing in relation to national security matters with respect to parliamentarians. In extremely breaking news, we received leave from the court today in a challenge concerning climate change, and CCLA will be intervening, which is a first for our organization. It's not the first time that we fought against government overreach or fought for maintaining fundamental rights during a time of crisis. We did it during the War Measures Act crisis. We did it during the Emergencies Act crisis, and we continue to say that the law has to maintain fundamental rights and basic freedoms, even in the face of unprecedented and complex crisis situations. We continue to advocate for independent oversight of the RCMP and the Canada Border Services Agency. The latter has no oversight body at all, despite deaths in custody, device searches at borders, and other rights violations. And finally, our education program is now one person bigger. We were joined by a wonderful colleague named Megumi Harker, who has a background in teaching, policy, and human rights work in the US and Asia. And our education program is everywhere. We've partnered with programs and institutions, including York, TMU, Wilfrid Laurier, the Laws Program, OGEN, Level Justice, public libraries across Canada, and school boards, both in and beyond the Toronto area. CCLET's education work encourages critical thinking on a wide variety of subjects, and we're going to be teaching everywhere in Ontario and Canada this winter. And we also have an exciting video project in the works, so stay tuned. Finally, you're going to get to hear about some of the extraordinary work of our equality program. So I'd like now to introduce our equality director, Harini Sivalingam. Harini is the director of the program. She oversees and executes advocacy strategies related to marginalized individuals and groups whose right to full equality has not been realized. Harini's work at CCLA includes monitoring significant equality issues and egregious violations across Canada, strategizing on litigation, public outreach, education, and engagement with policymakers of issues concerning equality. Harini was called to the Ontario Bar in 2006. She has a number of degrees, a BA from the University of Toronto, 2 law degrees, an LLB from Osgoode, and an LLM from McGill. And she's now completing her PhD in socio-legal studies at York University. Harini has advocated for low-income communities, as a law student and a lawyer working in community legal aid clinics, advocating for the rights of workers, of tenants, social assistance and ODSP recipients, newcomers, and refugee communities. For over 2 decades, Harini has been involved in anti-racism activity and community organizing on domestic and international human rights issues. Harini, your work on behalf of CCLA Fighting for Equality is inspirational and exceptional, and I'm delighted to now turn this over to you.
Thank you, Noah, for that very kind introduction. Good afternoon, and thank you all for taking the time to join us this afternoon to hear about the work that we are doing in the Equality Program at the Canadian Civil Liberties Association. This is a wonderful opportunity for me to not only provide you with a brief update on some of the key cases in the Equality Program that we're currently working on, but to also thank you for supporting the important work we do around promoting and protecting the fundamental rights and freedoms of all of us in Canada. As Noah mentioned, I am the director of the Equality Program. My pronouns are she and her, and the Equality Program is concerned with the promotion and protection of the rights of individuals and groups who face discrimination, whose rights to full equality have not been realized, and in particular, those who are most marginalized and vulnerable in our society. We recognize that for human rights and fundamental freedom to have any real meaning, they must be equally accessible to every person. This can be challenging in an era of increased polarization, where equity-seeking groups are often prime targets of those who seek to undermine human rights and fundamental freedom. In addition, there are many anti-rights groups who seek to exploit a false narrative of rights and freedom constantly in conflict with each other, and to capitalize on pitting equity-seeking groups against each other. CCLA is actively working on countering these narratives to highlight and demonstrate the interconnectedness of rights and freedoms, and that when rights, freedoms, and civil liberties are under attack for anyone, it affects all of us. There are many important and pressing equality issues that we are working on in the equality program. But this afternoon, I will be focusing on a couple of the key cases that CCLA has taken a leadership role in advancing legal challenges in the court. This isn't to undermine or underestimate all the other important work that we do that is non-litigation or not involving court systems, like law reform and public engagement and public education. But for the purposes of this talk, I wanted to provide an update on some of the key legal cases that we are currently involved in. So these include a challenge of racial profiling in Montreal, a legal challenge against Bill 21 at the Quebec Court of Appeal, a challenge of the Quebec school prayer ban, and a challenge to revisions of Policy 713 in New Brunswick that impact the rights of trans and gender diverse students. In this session, I'm going to share what CCLA is doing to advance the rights of vulnerable and marginalized communities and why it's important that we've become involved in these cases. I will begin with an overview of the work that we're doing with each of these cases, and then at the end, we'll open up the floor for questions and discussions. And I look forward to an engaging discussion with you after I've provided my overview. So I will begin with an update on our work challenging racial profiling in suspicionless vehicle stops in Montreal that resulted in a landmark ruling at the Quebec Superior Court that overturned a decades-long legal precedent that enabled the practice of racial profiling to continue without oversight. As you know, racial profiling is a lived reality for many Black, Indigenous, and racialized people that encounter regularly in their interactions with law enforcement. There's nothing truly random about these suspicionless roadside stops. They provide an opportunity for discriminatory policing and harassment, whether as a pretext or due to unconscious bias or systemic biases in structural law enforcement activities. There is no doubt that the practice disproportionately affects Black individuals, Indigenous peoples, and members of other racialized groups. Racial profiling undermines public confidence in law enforcement and the justice system as a whole. It also has serious, pervasive negative impact on individuals and communities. The heightened visibility and more encounters with law enforcement subject racialized individuals to an increased risk of police violence and abuse, which can lead to serious injury, long-lasting trauma, and even death. Arbitrary discriminatory police stops, even very short ones, are a serious interference with individuals' dignity, safety, and mental well-being. The fact that racialized individuals, in particular Black and Indigenous individuals, are more likely to be targeted by these police powers also means that their activities face greater visibility and exposure to police scrutiny, surveillance, and intervention. This heightened visibility is one of the many contributors to the overrepresentation of Black, Indigenous, and racialized individuals in the criminal justice system. So for example, because these individuals are more likely to be charged with administration of justice offenses or other offenses as a result. So laws that facilitate this unjust treatment also erode the perceived legitimacy of the police, the state, and the justice system as a whole. They make trust in and voluntary cooperation with public authorities less likely. The practice of racial profiling in particular undermines the belief and the expectation that all individuals are equal before the law. These are some of the important reasons why CCLA became involved in the legal challenge to put an end to this discriminatory, unlawful, and unconstitutional police power and practice. The CCLA has what is called conservatory intervenor status in a legal challenge launched by a young Black man in Montreal who has been routinely subjected to these types of unwarranted roadside stops. Having conservatory intervener status means that we played an active role in the 21-day trial, having equivalent status in the legal proceedings as the main parties, including the ability to examine witnesses, provide evidence, and make oral arguments. In a decision that was handed down on October 25th of last year, 2022, the Superior Court of Quebec declared that suspicionless police roadside stops were unconstitutional. That decision, a landmark decision that overturned a decade-long outdated precedent, declared that traffic stops were intolerable to those concerned because they are based on appearances and more or less conscious prejudice associated with the color of their skin rather than on the road safety objectives. The Attorney General of Quebec unfortunately filed an appeal of the court's decision to the Quebec Court of Appeal. We have recently filed our arguments in the court, arguing that the Quebec Court of Appeal should dismiss the government's appeal. We want to ensure that this decades-old precedent that was overturned continues to be overturned, and to uphold the decision to ensure that police powers that enable racial profiling continue to be recognized as unconstitutional. We anticipate to have, we don't have a hearing date set yet, but we anticipate a hearing date in the winter of 2024. So we'll look out for that, and we'll provide you with more updates once we have a hearing and we are able to advance our arguments at the Quebec Court of Appeal on this very important case to maintain to make sure that racial profiling and the powers of suspicionless vehicle roadside stop continue to be determined unconstitutional. So I'll move on to the next case that I wanted to provide you with an update, and that is the next two cases actually also in Quebec, where we are currently challenging restrictions on religious freedom of minority religious communities. So under the trope of the principles of secularism, the Quebec government has imposed laws and policies that infringe on religious freedom of minority religious groups in the province. The first case that I will discuss this afternoon is our legal case or challenge of Bill 21. The first of these two cases that attack religious freedoms is our challenge of Bill 21. So Bill 21 was passed by the Quebec National Assembly in June 16th of 2019 with the invocation of the notwithstanding clause in an attempt to preemptively shield the legislation from charter scrutiny. So we're creeping slowly towards the 5-year mark since Bill 21 was first passed, and the legal battle still continues. I mentioned that we're approaching the 5-year mark because this is the constitutionally imposed limit on the invocation of the notwithstanding clause, which can only be used in 5-year increments. The government of Quebec states that the purpose of Bill 21 was to enshrine the secular nature of the province into public administration by prohibiting wearing of religious symbols by certain employees of the civil service. As a result of Bill 21 that infringes on the religious freedoms of individuals who work in or want to work in the public service, it prohibits them from wearing religious symbols such as crosses, hijab, turbans, and yarmulkes. This impacts a wide range of public service employees, including but not limited to teachers, judges, lawyers working for the government, and police officers. So along with the teacher candidate at the time and the National Council for Canadian Muslims, the CCLA immediately launched the constitutional challenge of Bill 21. There was a partial victory in a complex decision by the Quebec Superior Court that recognized the inordinate harms done to individuals who wear religious symbols, and that decision struck down certain parts of the law as unconstitutional. Specifically, it could not apply to English language school boards due to the constitutional protection of minority language rights, and the law was also deemed inapplicable to members of the National Assembly itself. However, the decision kept most of the law intact and many of the recognized harms in play. That is why CCLA and both parties appealed the decision to the Quebec Court of Appeal. A hearing was held just last year in November of 2023, and at this time, we are still awaiting the decision from the Quebec Court of Appeal. Sorry, that was November 2022. And we're still expecting a decision any day now and any week now. We're not sure. It's been almost a year now, so it could be that a decision is rendered at any time right now. And we will again update you through our newsletters and through our press releases and website when we do have a decision on that. And obviously you'll hear about it in the media as well. The next case that also deals with religious freedoms in Quebec is a related case that we're challenging. And it concerns a prohibition on prayers in public schools in Quebec. So on April 5th, the National Assembly in Quebec adopted a motion that the establishment of spaces of prayers runs counter to the principles of secularism. Shortly after this motion was passed in April 19th of this year, the Minister of Education issued a directive prohibiting overt prayers and similar practices in and on school premises, which was later adopted as a decree. The responsibility of enforcing this decree fell onto the school boards, who are obligated to ensure compliance by local schools. The impact of this decree was immediately felt throughout Quebec's public schools and flagrantly violated students' rights of freedom of religion. After the decree was issued, students had reported that schools had prohibited them from praying in schools altogether. It became clear that this was not just a ban on prayer rooms, but an effective blanket prohibition on prayers within the school. In fact, the CCLA was contacted by two students who were directly impacted and affected by the prayer ban. CCLA, along with the National Council for Canadian Muslims and an affected high school student, launched the legal challenge of this school prayer ban as unlawful and unconstitutional. This prayer ban is yet another attempt to suppress the rights of religious minorities, but this time targeting children and youth in schools. While all religious communities are affected by the prohibition on prayers in schools, there is a disproportionate impact on religious minorities who cannot pray silently or discreetly, and who due to prayer schedules for devout observers may require to pray during school days. Our overall challenge of the prayer ban is based on our position that the government cannot lawfully prohibit students from praying in schools, and such a ban violates religious freedom under both the Canadian and the Quebec Charter. The school prayer ban is discriminatory. It creates a distinction between students, religious and non-religious students, and impacts some religious communities and genders more than others. For example, those who cannot pray silently or discreetly. In addition, the prohibition on prayers prevents schools from being able to provide reasonable accommodations to students who request it. Moreover, the blanket prohibition on prayers has had detrimental impacts on the dignity and well-being of students, and it's not in the students' and children's best interest to have their religious freedoms and rights violated. In June, we asked the court to suspend the enforcement of the decree due to the significant harm to children in Quebec schools until the court can determine its constitutional and legal validity. While the court did find that there was irreparable harm caused to students whose rights to religious freedom was being violated, the justice unfortunately did not agree that this reached the threshold of urgency and that the public interest did not warrant the suspension of the decree. So they denied our request for an injunction that would have suspended this decree. And so we are currently preparing to have our case heard at the court to determine the constitutionality and legality of the school prayer ban in Quebec. So again, we'll have more information once that's available, but I just wanted to provide you with this case that we have recently launched over the summer. The next issue in the equality program that we've been working on recently that I wanted to highlight is our advocacy on revision to Policy 713 that roll back protections of trans and gender diverse students in New Brunswick public schools. So the original Policy 13, and I'm sure that some of you have already heard about this issue in the media, as it's been widespread reported about the use of the government in New Brunswick and Saskatchewan using policies and restricting the rights of trans and gender diverse students in those provinces. So I'll give you a bit of background on the policy itself that's in New Brunswick that is being affected, and the rights of those young people that are being restricted and infringed upon. The original Policy 713 was introduced in 2020 after extensive consultation with stakeholders, parents, students, teachers, and community members to create minimum standards and protections for 2S LGBTQIA+ students. So the intent of the original Policy 713 was to create a safe, inclusive, supportive learning environment for all students in schools. Local community organizations have stated that since the policy was established, it was working and was having a real impact on supporting students in schools. And similar policies exist in other jurisdictions across the country to support and create the safe, welcoming, inclusive environment for 2S LGBTQIA+ students. However, in June of this year, the Minister of Education in New Brunswick unilaterally unveiled revisions to Policy 713 that eroded these minimum standards and weakened the protections that specifically targeted trans and gender diverse students. These revisions were made without consultation with school communities, parents, students, or affected communities. The Child and Youth Advocate in New Brunswick conducted a thorough review of the changes to Policy 713 and concluded that the new policy violated the rights of trans and gender diverse students and made important recommendations to the province to implement and even drafted a model policy that would uphold the rights of trans and gender diverse students. The Minister of Education ignored those recommendations and made further revisions to the policy in late August that reinforced the harms and discriminatory nature of the policy by clarifying that the policy only applied to trans and gender diverse students, and also clarifying that that students are not able to use their chosen pronouns and names in the informal classroom setting without parental consent. The revised Policy 713 restricts students under the age of 16 from using their chosen names and pronouns in school. These policy revisions have drawn condemnations in both its process and substance. The rollback of inclusive education guidelines in Policy 713 threaten the safety and well-being of 2S LGBTQIA+ students and increases the risk of facing discrimination and violence. The sad reality is that for many trans and gender diverse students, school may be the only safe space they have to express their gender identity. And being involved in this important issue, it's important for CCLA to stand up for trans and gender diverse students who are a very vulnerable and marginalized population. Since June, the CCLA has been closely monitoring the developments in New Brunswick and have meeting regularly with local communities involved in advocacy on this issue. In September, the CCLA launched a legal challenge of Policy 713, which we believe infringes on the rights and freedoms of trans and gender diverse students in the province. We have filed our application with the court along with supporting materials, and we have a hearing scheduled for October 25th of this year, so in a couple of weeks actually, to determine the public interest standing to pursue this matter further. Similar to our advocacy on the Quebec school prayer ban case, we believe, and we know that people in Canada believe, that every student deserves to feel welcome, respected, and safe in school. CCLA is also intervening in a legal challenge of a similar policy in Saskatchewan. In that province, the court has granted an injunction that temporarily suspends the policy until the court could determine the constitutional validity of the Saskatchewan policy. And as you've heard already in the news, and that you've heard from Noah earlier in the introduction, the Saskatchewan government has recalled legislation yesterday to introduce, the legislature to introduce legislation to implement the policy with the notwithstanding clause. And the government of New Brunswick has also previously threatened to invoke the notwithstanding clause in relation to changes to Policy 713. They haven't actually they haven't actually introduced any legislation in New Brunswick, but they have threatened to do that as well previously. The CCLA is committed to demand that government education policies respect the rights of trans and gender diverse students, and our legal challenge is in New Brunswick and our intervention in Saskatchewan are two ways that we are using the legal tools available to ensure that trans students' rights are respected and protected in those provinces. So it's been, in conclusion, it's been a very, unfortunately, a busy summer in the equality program. I say unfortunately because we have seen, as you've seen with these cases that I've been discussing this afternoon, we are seeing government and state actors increasingly implement laws and policies and practices that violate the fundamental rights and freedoms of vulnerable and marginalized groups in Canada. And alarmingly, as Noah mentioned in the introduction, there's also this growing use of the notwithstanding clause as an attempt to violate the fundamental rights of the utilization of the notwithstanding clause as a means to ensure that these legislations and policies are enforced despite any potential constitutional issues of the infringements of the rights that are at play in those policies. The CCLA is committed to fighting and to advance equality for all of us in Canada, and especially the most marginalized and vulnerable groups in our society. So I now look forward to answering any questions that you may have and to a fruitful discussion. And I'll pass it on to Michael, who will moderate the questions. So I believe that the Q&A is open. So if you have any questions that you would like me to address, please feel free to use the Q&A function to type in your questions. So Michael, take it away.
Thank you, Harini. So yes, as Harini said, the Q&A is now open. If you have any questions, please feel free to put them in the Q&A. We'll try and get to as many as possible. We have approximately 25 minutes left. So the first question I have for you, Harini, is which charter rights do you think are most under attack right now?
Oh, that's such an interesting question. So, I mean, I'm going to maybe flip that to what groups are more fundamentally under attack. So I think I alluded to this a little bit earlier in my remarks, which is what I'm seeing is that equity seeking groups. So you're seeing these far right, anti-rights, apologies, like anti-rights movements and groups that are really attacking the rights of very vulnerable and marginalized groups in society. So you see that very much with the case of trans and gender diverse students that are being attacked and their rights are being violated. So we're seeing particularly vulnerable and marginalized groups that are at the forefront of these of movements to erode the protections of rights. So I would say, in terms of linking that back to charter rights, because I am the director of equality, I would say that Section 15, like those equality rights, are probably the ones that I am seeing in my program area as being the ones that are most fundamentally under attack. But this is also to say that rights are very much interconnected. So in order to have your rights, your fundamental freedoms respected, you really need to have equal access to all of your rights. So I would say that Section 15 is probably one of the most fundamental rights that are at stake right now. And it's also one of the rights that the courts have a little bit more difficulty, I would say, tackling. We're seeing Supreme Court cases that look at Section 15 equality, jurisprudence, and we're seeing, courts, I don't want to say not get it right, but we're seeing, courts having difficulty with Section 15 equality rights and really enforcing the equality, like the fundamental substantive equality rights that should be guaranteed to all people, but in particularly marginalized and vulnerable groups in our society.
Thank you, Harini. So the next question I have for you is, on Bill 21, the decision has been pending for some time now, so November 2022 of last year. You spoke about coming up to the 5-year limit on laws invoking the notwithstanding clause. Is there a reason why the Court of Appeal is taking so long? Is this normal for an appellate court? Is there any chance that this will not go to the Supreme Court of Canada? And what prevents the Quebec government from capitalizing on the clock being run out in this specific appeal and just renewing over and over? So essentially, what's going to happen at the end of the 5 years? What's their options?
Yeah, so that's a really great question. Like, obviously, I can't speculate on the court and what the reasons are for for not having a decision at this time. I would say, like, there is no typical time frame. Like, courts can take as long, really, they can take as long as they need to render a decision. The typical time frame that we generally see is 6 to 8 months for a decision at the Court of Appeal level to be rendered. So we're past that mark. So I don't want to speculate on the reasons for that. It is a complex case, and I can't really speculate on the reasons for not having a decision at this moment. But what I would say in terms of the 5-year mark and what happens, right, if we is that basically that the legislature has to reenact the law once you've reached that 5-year mark. So in the case of Bill 21, that would be June. Let me go back to the date specifically, but it would be like June, and then 2024. They would have to reenact the legislation with the notwithstanding clause again. And that would be valid for another 5 years. So that's what the process would be. I think there was another question in there, but I didn't really catch it. I hope I addressed all the questions in that.
Yeah, you did address it. The second follow-up question, so essentially what's their options and what's going to happen when that 5 years is up for the Quebec government?
So they would have to reenact, yeah. So they would have to reenact the legislation with the notwithstanding clause, because after 5 years, that's the time limit in the Constitution for the validity period of the notwithstanding clause. So remember, I think as Noah mentioned, the notwithstanding clause is it's a clause that was used, it's not supposed to be widespreadly used, and so the drafters of the Constitution, when they were when they put this provision into the Constitution, wanted to ensure that there was a time limit so that rights and freedoms cannot be suspended indefinitely, and they put a time limit of 5 years for the notwithstanding clause for the validity of that. So every 5 years, if the government wants to ensure that legislation stays in place, they would have to reenact it with the notwithstanding clause after 5 years.
All right. And so the next question I have is concerning the Quebec prayer ban in schools. Does the Quebec prayer ban include First Nation students doing a smudging ceremony?
That is very interesting. I'm not sure if I can answer that because there might be some, because of the distinct nature of Indigenous communities. And I know that it doesn't apply to Indigenous schools so the prayer ban only applies to certain schools. So I know for a fact it doesn't apply to Indigenous schools itself, but I'm wondering, like, it could possibly, I don't want to speculate, but I mean, I guess there could be an argument that it could apply to an Indigenous student in a school board that where the policy or the decree does apply to. But there's also, other issues around, like, First Nations relationships to, like, in governance that may be at play. So I'm not in the best position to be able to answer that question definitely.
So the next one concerns policy 713. So when it concerns parental rights and the rights of children in school, can you talk about how the CCLA balances those rights?
Yeah, so I want to start off by saying fundamentally that CCLA believes that parents should be involved in their children's lives, and they have an important role to play in the upbringing of their children. At the same time, our position is that laws should not violate the rights of young people. That the charter, it applies to everyone, and that includes young people and students. And youth, right? So our position is that that the state should not be acting in a manner or invoking policies or enacting laws that restrict or infringe young people's rights, and that, especially that ones that harm young people. There's also the legal principle of the best interest of the child, which is a legal principle, and that government should be all decisions and all actions of government must take into account and consider the best interests of young people and students. And I would say that applies to both, all cases that deal with students and rights in various contexts.
So our next question is regards to New Brunswick and Regulation 8420, and that would be on reproductive and the access to abortion. Is there any updates on that case?
I'm glad that question was asked. At the moment, we are still awaiting a hearing. So there's a lot of procedural things. So as you know, court proceedings are very slow. So at this time, we're just waiting for a hearing date to be set on that case. So part of the legal proceedings is examining witnesses and producing affidavits and evidence. And then once a party produces some evidence and affidavits, the other party can question or examine that. So ask questions of the affiant or the person that swore the affidavit. So that process has been playing out in the background. So we don't have a hearing date set just yet, but as soon as we do, we'll make sure that all of you are updated through our newsletter and through other channels.
Perfect. So just give me 1 second. I'm just waiting for more questions. All right. So I have one from a person. He just has a specific case. He wants to know, I had a small rainbow sticker on my volunteer ID badge, and I was told to remove it by festival staff because it was considered branding. I filed an HRTO complaint under sexual orientation, and have clearance for a tribunal date. I see my issue similar to Quebec's S21. Is there any comments on that?
So we can't we can't give specific legal advice, and I don't want to comment on specific legal issues or specific cases. But I guess I would just say that that just in general that to I wouldn't even know. Sorry, I don't even know. I don't want to comment on that because it's very specific to a case. So I'll just leave it at that.
All right, so this next question is about the notwithstanding clause. Have you considered challenging the use of the notwithstanding clause on the basis of rights that existed prior to the Charter, which are maintained specifically in Section 26 of the Charter?
So I don't have a comment on that. I'm wondering if Noah or ED wants to weigh in on the notwithstanding clause. And
Yeah, thanks, Harini. We've been very concerned about the use of the notwithstanding clause in Bill 21, egregious use against people's freedom of religion, Christians, Jews, Muslim women from minority community groups in particular. And then Ontario, freedom of expression, and then freedom of association, now Saskatchewan equality rights, and so it goes on. The question of how to challenge it is extremely tricky, but it has been raised, and it has been raised in the Bill 21 challenge in court, and we'll see what happens in Saskatchewan as well. There were attempts by several of the parties to try and address it within the specific context of the Bill 21 challenge, which is the religious symbols ban. So Canadian Civil Liberties Association, together with another organization, as you heard, challenged the law, but after that, there were 3 other challenges that were filed. There are many interveners as well, which also perhaps answers the question as to why this is taking so very long. It's 4 different challenges together. And some of the arguments that have been raised have been about the notwithstanding clause, and some of those include using Section 26, the rights of women, the rights of gender equality, to protect the underlying rights. So all of that is before the Quebec Court of Appeal. And, depending on what happens and depending if there's an appeal, it may also go up to the Supreme Court of Canada. So some of those issues are being played out within the Bill 21 challenge.
Harini, do you have anything to add, or I'm just waiting for further questions? So.
Well, I just wanted to clarify. I think no one mentioned. I think you mean Section 28, right? On the equality of women and men.
Yeah, that's right.
Yeah.
All right, so I have the next question. So there seem to be a lot of equality rights violations going on right now, and we know that rights are being rolled back in many countries around the world. Does it seem that things are getting better in the area of equality or worse over the past 5 years or so?
So I am the eternal optimist. So I would say that yes, you're seeing across the world violations of equality rights in various contexts, right? Specifically targeting the most vulnerable and marginalized members of our society. But at the same time, you're seeing resistance to that. You're seeing people using legal tools and political tools and advocacy to strengthen and reinforce equality rights. So I think and we see that in Canada, especially we're seeing, the work that we're doing, the work that you are helping support us in doing is part of that resistance and part of that movement to ensure that we keep moving and advancing, and that we keep moving forward in the advancement of equality, and so that we're not just that we're always that we'll be in a better place, and that the world that we leave behind for next generations to come will be better than the world that we are living in at the moment, right? So it might be a naive and optimistic way of seeing this, but I think that's why I'm in this role, is to continue this work that is challenging at times, especially when we're seeing this onslaught of rights violations at various levels of government and internationally. And at the same time, it's what keeps me motivated, and it keeps going on these kind of files and these issues. So I would say yes, it's challenging, and that we are seeing these widespread violations. At the same time, I'm seeing opportunities to challenge them and to advance the quality, so that we are that we're in a better place in the future.
Thank you, Harini. So I'm just waiting for the next question to come up. So just a reminder, we have about 10 minutes left. If anybody wants to get any questions, you can put them in the Q&A below.
So if I can jump in with a different perspective than that of Harini's on the last question, while we're waiting for the next one to come in, I think that we are seeing some very dangerous trends around equality rights. I mean, there's always has to be room for optimism and has to be room for hope, and there certainly has to be energy for fighting. But at the same time, we're seeing a rollback on reproductive freedom in the United States. We're seeing a rollback on trans rights in Canada, and it's closely tied, transphobia to homophobia. And we have to be alert to the possibility that trends that we are seeing in the United Kingdom, in the United States, and in other Western democracies, let alone other countries in the world, could be trends that are going to arrive in Canada as well. And it's why we have to double down and why we have to work as hard as we do to ensure that people in Canada understand the importance of our rights and freedoms and how they protect all of us, understand how the notwithstanding clause threatens all of our rights, every single one, whether it's freedom of expression or the right to protest or privacy rights or protection from government overreach or the right to a fair trial. And every other right is threatened, or almost every other right is threatened by the use of the notwithstanding clause, because people in this country care deeply about rights and freedoms from across the political spectrum. And the connection between those is something that we're working very hard to establish so that everybody understands that we are, as Harini said, we are all impacted, that this is something that threatens a particular group today, but it threatens all of us into the future.
Thank you, Noah. And so I have a question. The next question is, do you have suggestions on how people can help push for equality rights and express disdain at tools that clearly go against civil liberties, such as the notwithstanding clause, beyond donating to organizations or manifesting when issues hit the news cycle?
Yeah, so I would say using your voice, and speaking out for to decision makers, to government, to policymakers, lawmakers, that that rights and freedoms are important to you. They're important to all of us in Canada. That these are values that we all hold. Everyone in Canada respects and values rights and freedoms. And that you won't tolerate the undermining of these rights and freedoms. So I say use your voice, in terms of advocating towards elected and non-elected officials, and to speak out about them, to engage with colleagues and friends at the dinner table about these important human rights, civil liberties issues that we're hearing about in the news, and to talk and engage with others about the importance of rights and freedoms and equality, and promoting and respecting equality and rights and freedoms. And obviously, I guess supporting the work that we do, through financial donations, and other organizations that you believe in that are doing similar work, right? Specifically. So those all help to advance equality and to advance these issues.
So it's 3:55, so we have time for one last question. So the last question is, Harini, do you work in partnership or coalition with other organizations?
So yeah, so I mean, we definitely work with organizations in various contexts. So I'll give you specific examples. Like, so in litigation, we are co-parties with community organizations in Bill 21 in our challenge of Bill 21, as well as our legal challenge in the Quebec school prayer ban case. We also work in consultation with affected stakeholders. So in our challenge of policy 713 and in abortion access in New Brunswick, we're very in tune to the local community groups and in touch with them about how these policies and laws are affecting local communities and strategizing with them on the best advocacy tools to, you know, and just to make sure that we're really attuned to what the local community needs are and what the issues are and what the impacts of these laws and policies are on local communities. So we do work very closely with community organizations on all not just on these issues, but also, you know, in terms of law reform, we consult with community organizations and collaborate in submissions and in public engagement on these issues as well.
So it's a couple minutes to 4, so I'm just going to ask Harini or Noah, did you have any concluding remarks to make?
So I'll just begin by saying thank you for your time today and listening to our quality program briefing. And I just want to underscore that the work we do is really is tied to the support that you give us. Like, we wouldn't be able to do all of this work without you know, supporters and donors that help us to carry out this important work. So thank you for your time and your attention today and hearing me provide this equality program update.
Yeah, I would just like to add as well, really a very warm thank you, Harini, for that incredible presentation and for sharing the amazing work that you're doing. I want to thank each and every one of you for coming and for participating and for your questions and your challenges and your interest. And thank you as well for the very kind comments that you've posted. We very much appreciate it. And for your incredibly generous support that allows CCLA to continue doing the work that we are doing, that supports the values and the rights and the freedoms that we all find so important and that we share. So thank you.
Perfect. And we're going to wrap it up now, but I'll just add in, there will be a recording sent around to everybody. So if you want to watch this again live, we'll be sending that around in a few days' time. But thank you everybody for coming, and we hope to see you at the next briefing.